Missouri has a landlord-friendly late fee framework with minimal state-level regulation, giving landlords broad discretion over fee amounts and timing. The governing law is found in Missouri's Landlord-Tenant statutes, Missouri Revised Statutes, Chapter 441, along with general contract principles. Missouri has not adopted a comprehensive version of the Uniform Residential Landlord and Tenant Act, and the landlord-tenant relationship is governed by a combination of limited statutory provisions, common law, and the lease agreement. If you're a landlord or tenant in Missouri, the lease is your primary governing document for late fees. Let's start with the basics. Missouri does not impose a specific statutory dollar cap or percentage cap on late fees. There is no statute that limits the fee to a certain amount or percentage of rent. The fee amount is governed entirely by the lease terms and general contract principles. Missouri also does not mandate a grace period. There is no state law requiring any specific number of days before a late fee can be charged. If your lease says rent is due on the 1st and a late fee applies on the 2nd, that's enforceable under Missouri law. However, most Missouri landlords include a grace period of 3 to 5 days as standard practice. The key legal principle is reasonableness under Missouri contract law. A late fee is a liquidated damages provision, and Missouri courts have a well-developed body of law on liquidated damages. Under Missouri's framework, a liquidated damages clause is enforceable if two conditions are met. The damages from the breach must be difficult or impossible to calculate precisely at the time the contract is formed, and the amount fixed must be a reasonable estimate of the probable damages. A fee that fails either test is an unenforceable penalty. Missouri courts have addressed late fees in the residential rental context. The general standard is that the fee must bear a reasonable relationship to the landlord's actual costs, not serve as a profit center or punishment. Administrative time, follow-up communication, bank fees, additional accounting, and the time value of money are all legitimate cost components. What's reasonable in Missouri? Industry standards suggest that a flat fee of $25 to $75 or a percentage-based fee of 5 to 10% of the monthly rent is generally defensible. Missouri has moderate rental markets. Kansas City and St. Louis rents typically range from $800 to $1,500, and smaller communities are more affordable. A $50 fee on a $1,000 rent, 5%, is well within the reasonable range. A $200 fee on the same rent, 20%, would likely be struck down. Missouri's Merchandising Practices Act, found in Chapter 407, prohibits unfair and deceptive business practices. While the act primarily targets commercial sales, it has been applied to landlord-tenant situations in certain circumstances. Systematic overcharging of late fees, particularly if the fee terms were not clearly disclosed, could trigger a claim under the Act. The Act provides for actual damages, punitive damages, and attorney's fees. The lease must clearly state the late fee terms. Given Missouri's limited statutory framework, the lease is the primary document that governs late fees. The lease should specify the rent due date, any grace period, the exact fee amount or formula, when the fee triggers, whether additional charges apply for continued non-payment, whether the fee is defined as additional rent, and how partial payments interact with the fee. Ambiguity is resolved against the landlord, so clarity is essential. Compounding late fees in Missouri are governed by the lease and the reasonableness standard. A single one-time fee after the grace period is the simplest approach. If your lease includes daily or weekly charges, the total must remain reasonable. A compounding structure that could produce fees exceeding 15 to 20% of the monthly rent within a few weeks would likely be deemed an unenforceable penalty. The interaction between late fees and the eviction process in Missouri is straightforward, but varies between Kansas City, St. Louis, and the rest of the state because of jurisdictional differences. Missouri generally does not require a specific pre-eviction notice period for non-payment. The landlord can file for eviction immediately upon non-payment, unless the lease requires notice. However, some jurisdictions, including Kansas City and St. Louis, have local procedures and court rules that effectively create notice requirements. The amount demanded in the eviction filing must be accurate, including only compliant late fees. Whether late fees can be included in the eviction demand depends on the lease. If defined as additional rent, they're includable. If not, the landlord may need to pursue them separately. Best practice: define late fees as additional rent. Missouri's Associate Circuit Courts handle eviction proceedings, known as rent and possession actions. The process is relatively fast in most Missouri jurisdictions. Non-compliant late fees included in the demand give the tenant grounds to challenge the amount, which can delay the proceedings. Missouri does not impose a statutory cap on security deposits. The deposit amount is governed by the lease. The deposit must be returned within 30 days with an itemized list of deductions. Unpaid late fees can be deducted if the lease authorizes it, and the fees are reasonable. Wrongful withholding can result in the landlord being liable for up to twice the amount wrongfully withheld. Kansas City and St. Louis have each enacted local tenant protections that may affect late fee enforcement within their jurisdictions. Kansas City passed a Tenants' Bill of Rights and has been active in expanding tenant protections. Kansas City landlords should verify current local requirements that may impose additional obligations regarding late fees, notice requirements, or fee disclosures. St. Louis. Both the city and St. Louis County has a complex rental landscape with various local regulations. The City of St. Louis has specific housing regulations that may affect fee practices. St. Louis County municipalities each have their own rules, creating a patchwork of requirements across the metro. Landlords operating in both Kansas City and St. Louis need to understand the local overlay in each jurisdiction. The late fee provision that works in rural Missouri may not comply with city-specific requirements. For tenants receiving Housing Choice Voucher Assistance, common in Kansas City, St. Louis, and other Missouri cities, landlords should not charge late fees when the housing authority's portion is delayed due to processing. The tenant cannot control the authority's timeline. If the tenant's portion is paid on time, the fee should apply only when the tenant's own payment is late. Missouri's military population is significant, centered around Fort Leonard Wood in the Ozarks and Whiteman Air Force Base near Knob Noster. Fort Leonard Wood is the Army's primary engineer, military police, and chemical training center, with constant trainee and instructor rotation. Whiteman AFB is home to the B-2 Stealth Bomber Wing. Military pay is predictable, and most military tenants pay reliably. Fort Leonard Wood's training mission means constant PCS turnover. New military tenants arrive regularly and may need a pay cycle to establish direct deposit. Some landlords near Fort Leonard Wood accommodate this by being flexible with first-month payment timing while establishing clear expectations for subsequent months. Whiteman AFB near Knob Noster generates demand in the Warrensburg and Sedalia area. The B-2 mission attracts a professional workforce that generally pays reliably. From a practical standpoint, Missouri has two major metros with distinct market dynamics, plus secondary markets across the state. Kansas City is one of the most balanced rental markets in the Midwest, affordable relative to national standards with steady demand. The economy is driven by healthcare, financial services, technology, logistics, and government. Rents typically range from $800 to $1,500. Most Kansas City landlords charge flat fees of $35 to $75 with a 5-day grace period. The Kansas City Metro straddles the Missouri-Kansas border. Properties on the Kansas side are subject to Kansas law, which has different late fee standards. Landlords operating on both sides need different provisions for each state. St. Louis has a diverse market with significant variation by neighborhood. The city proper has experienced revitalization in areas like the Central West End, Soulard, and Tower Grove, with increasing rents and a professional tenant base. North St. Louis and parts of South St. Louis have more affordable rents and higher late payment rates. St. Louis County spans from premium West County suburbs to more moderate North County communities. Washington University, St. Louis University, and other institutions create student demand. Student late payments correlate with financial aid processing. Columbia, home to the University of Missouri, has a tight student market. Student late payments at the beginning of each semester are common. Springfield, home to Missouri State and Drury, has a moderate market with some student influence. The Lake of the Ozarks region has seasonal tourism dynamics. Branson has a tourism-driven economy where hospitality workers may have irregular income patterns. Joplin, Cape Girardeau, Jefferson City, and other Missouri communities have moderate to affordable markets. One best practice for Missouri landlords, because the state has no statutory cap, your lease must do all the work. Include a detailed late fee provision that covers every element: due date, grace period, fee amount, trigger date, compounding rules, and definition as additional rent. In a state where the statute provides minimal guidance, your lease fills every gap. Another best practice: set your late fee at a level that's defensible under Missouri's liquidated damages standard. Document your actual costs: staff time, system processing, late notices, bank fees, and set the fee at or near that level. A fee supported by documented costs is virtually immune to challenge. A fee that's 3 or 4 times your actual costs is vulnerable. A third best practice: determine whether your property is in Kansas City, St. Louis, or another jurisdiction with local provisions that may affect late fee practices. Missouri's patchwork of local regulations means that the same fee provision may be compliant in one city and non-compliant in another. When in doubt, build your provision around the most restrictive requirements that could apply. For the complete guide to Missouri late fee laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our late fee law series.